Welcome to episode 3 of the Wikipedia Rocks the Endangered Species Act video series. I'm the principal author, 71% of that Wikipedia page over the past 2.5 years. I'm Connie Barlow, and today is April 6th, 2026. And I'd like to mention my credentials very quickly in this third part. As always, I'm a retired science writer. These are 4 of my books. The lower 2 here, early 90s. This was MIT Press that published it. Then Springer. And then finally Basic Books, my last book in 2001. And so I've put a lot of effort into reading law review articles, scientific papers, environmental ethics, academic journal articles, and so forth. But another reason why I feel really qualified to be able to work on a tutorial here of what's in that Wikipedia page is for 2 decades I've been working as a citizen volunteer for one of the endangered plants, Terrea texifolia. And I talked about that in more detail in the first 2 episodes. But in this one here, this is part 3, and this is where we're starting into the longest section that I wrote within that Wikipedia page. And that section is titled Challenges and Controversies. It has 29 subsections to it. This was just beginning, and there'll probably be 2, maybe 3 more episodes after this one to finish it off. So let's get started. As with the previous 2 parts in this series, we'll begin with the Wikipedia page itself, the Endangered Species Act of 1973, and we'll look at the table of contents. Episode 1 already covered the intro part and all of the sections within the history part. Part 2 covered features of the 1973 Act as amended, and all of these components were dealt with. The rest of the video series will deal with challenges and controversies. Now there's a total of 29 of them in here. And so it's likely going to take us somewhere between 3 and 4 parts to get through this. So we'll start on the introduction to the challenges and controversies. Here's where it takes us to the Wikipedia page, Challenges and Controversies. But as I've been doing, I always go to a PDF that I previously downloaded so that I could highlight and know how to read this. All right, Challenges and Controversies. The Endangered Species Act of 1973, ESA, is regarded as one of the most powerful and controversial environmental laws in the United States. In 2023, with the Act achieving its 50th anniversary, journalists were prompted to report on the Act's outcomes and controversies. Congressional overturning of several recent listings and ability to hamper implementation by restricting agency funding were among the points mentioned by some media. A foundation associated with the Western Caucus of U.S. Senators and Representatives issued a 116-page report in 2023 titled The Endangered Species Act at 50, with a subtitle expressing its primary criticism that, quote, a record of falsified recoveries underscores a lack of scientific integrity in the federal program. Now we'll talk about that at another section. Using the same title but reaching an opposite conclusion, the Center for Biological Diversity focused on how many species were prevented from going extinct in the past half-century. Before I continue reading, we're going to take a look over here at this reference. Any reference that I put in pink is a sign to me that I'm going to click on it. All right, so this takes us to the references part of the Wikipedia page. 3 times it's been used, and it's the Eco-Species Reports. We'll click on that. And that takes us to the U.S. Fish and Wildlife Service, ECOS, Environmental Conservation Online System. And I always go here at the beginning of each episode in this series because this is essential. This is where you can look, and everything in blue or purple here is a distinct, usually a tabular formulation of everything that it says. So, Fish and Wildlife Service listed U.S. species by taxonomic group, listed species summary, box score, issued biological opinion report. The ones in purple I've looked at recently here. Species with critical habitat, species with recovery plans, species with 5-year review, on down to species status assessments, species proposed for listing, and so on. Among the faculty expressing 50th anniversary views in a University of Pennsylvania report, one drew attention to an underlying shift in national worldviews during the past half-century. The act, quote, reflects the confidence of mid-20th century liberal politics that any problem can be fixed with legislation based on scientific data. Yet, pragmatic solutions that require flexibility have been hindered and polarization has become intense. An academic review paper in 2008 reported that the act had become, quote, a social, legal, and political battleground, and that the scientific question of whether the ESA works effectively to protect species remains open. Indeed, endless litigation has become a defining feature of ESA implementation. I'm going to just move through this quickly here and just mention the ECOS Environmental Conservation Online Systems. That's what we just looked at. Now we'll move on to the first subsection title. Context of state-level endangered species programs. Because some of the challenges and controversies arising from implementation of the Federal Act entail interactions with various state governmental priorities and programs, it is important to establish the background of state jurisdiction. A lengthy report prepared by the Congressional Research Service, CRS, and periodically updated states. Section 6 of the ESA requires the Secretary to cooperate with the states to the maximum extent practicable in conserving federally protected species. Fish and Wildlife Service and courts have recognized the state's key role in regulating wildlife and catalyzing conservation efforts by landowners and communities on private land. The report also noted that the 1988 amendments to the Act established the Cooperative Endangered Species Fund, which is to provide funding for state grants, including land acquisition and planning assistance. In 2000, Congress initiated the State and Tribal Wildlife Grants Program, portions of which have been used to assist recovery of federally listed species and to install projects that could preclude the need to list new species. A 2025 Congressional Research Services report is titled The Role of the States Under the Endangered Species Act, ESA. A 2024 report commissioned by the National Caucus of Environmental Legislators is titled A Natural Legacy for the Future, State Laws for Endangered and Threatened Species. Both difficulties and successes in state-level actions and across-state cooperation are highlighted in this 179-page report. For example, downlisting of the Chiricahua leopard frog from endangered to threatened is attributed to state-level efforts by Arizona and New Mexico. The need for a federal listing of the Marden skipper butterfly was avoided, owing to cooperative early efforts by the states of Washington, Oregon, and California. In practice through the decades, the federal-state relationship has not always been congenial. Elected officials at both federal and state levels sometimes escalate calls for outright devolving endangered species management to the states. An overall federal policy for collaboration, however, is not achievable because the kinds and scale of species protective laws, regulations, and implementation priorities vary enormously among the states. Examples of state-level diversity are that, 1, only 18 of the 50 states automatically include in their own lists all animals and plants listed by the federal act that are present in their state. So again, that's only 18 of the 50 states automatically do that. Secondly, 17 states offer no protection for any plants. And thirdly, West Virginia and Wyoming have no statutory support for protecting even animals threatened with extinction. As well, only California and Oregon authorize citizens to petition for state-level listings, and distinctions prevail in matters concerning critical habitat designations and the degree to which species protections can impinge on land use choices by private owners. Nothing prevents a state from issuing stricter regulations for a federal listed species within its boundaries. A 2018 survey of state laws found that Illinois, Massachusetts, and Wisconsin, quote, even go beyond the ESA in their protective measures. As well, nothing prevents a state from listing a species that the U.S. Fish and Wildlife Service formally decides against. An example of federal-state tensions occurred in California in July 2023. It was then that California enacted its own Western Joshua Tree Conservation Act. This halted all sales of the western species of Yucca brevifolia, which had been used in a lot of nursery sales, while instituting a permit process for any proposed removal, harm, or trimming of the species on private lands. The legislature itself chose to pass this law after the federal agency had formally decided against listing on 2 occasions, August 2019 and March 2023. The second decision had been forced by a 2021 court remand of the 2019 decision. It's getting complicated. And was based on a species status assessment report 173 pages long that had been published by the agency the prior month. So I'm going to overlay here now a map that appears in the species status assessment report. All colors combined is where Joshua Tree is found today. Projecting future climate change, habitats will shrink away from the lower elevations, which are shown in yellow, while the higher elevations, the darkest green, become the climate refugia. And that means that's the last place where they're going to be able to survive if climate changes, as some of the official reports seem to suggest. Now we're going to skip that technical area there and move into here. Despite the state of California's initiative, a national environmental organization, Wild Earth Guardians, went to the federal court system again. In May 2025, the court ruled in their behalf. As reported in a news article, quote, when deciding whether the Joshua Tree should be considered threatened or endangered for the, quote, foreseeable future, the U.S. Fish and Wildlife Service only considered the future through 2069. The court ruling determined that the agency's definition of the foreseeable future was, quote, arbitrary and capricious, and that the agency, quote, did not use best available science regarding the threat of climate change, among other findings. A 2018 research law paper presented the importance of state-level jurisdiction and collaboration in this way, quote, the Endangered Species Act, ESA, may well be the most contentious of the federal environmental statutes. It certainly is the most controversial of the conservation laws outside the purview of the U.S. Environmental Protection Agency, EPA. Yet, in congressional hearing after congressional hearing, one consensus rises above the rancor. All parties agree that states should play a greater role in preventing extinctions. In October 2025, the state of California once again took actions to supersede federal ESA implementation. A new law was enacted and signed that enabled the state agency to quickly designate a plant or animal as a, quote, provisional candidate species for state protection if a federal action or regulatory change, quote, could result in a decrease in endangered or threatened species protections by the federal government. That same month, the California Department of Fish and Wildlife euthanized 4 federally endangered wolves that had recently established in a cattle ranching part of the state. The agency explained that a small wolf pack had become, quote, so reliant on cattle at an unprecedented level, and we could not break the cycle, which ultimately is not good for the long-term recovery of wolves or for people. Just a note by me. I've had experience with both wolves and grizzly bears in Alaska, and I can see both sides. Yet the opposing parties are so dug in, it's hard to imagine any agreement happening across the aisle in Congress. Moving on to the next subsection, executive, legislative, and judicial entanglements. The petitioning, listing, and recovery planning stages prescribed in the Act have a history not only of contentiousness, but of delays and setbacks owing to all 3 branches of the federal government sometimes becoming involved. This is especially the case when a federal listing would apply to an animal whose widely dispersed populations are declining over a vast landscape. Potential listing of the lesser prairie chicken is one such example, and you can see the range there over at the right. The orange is where it probably used to have been and may be extinct, but where they really know it still is and are residents is where it's blue. In 1995, the Center for Biological Diversity, along with other conservation groups, petitioned for listing the lesser prairie chicken. Agency recognition of the bird as a, quote, candidate species in 1998 deferred formal review while the agency worked its way through a backlog of previous petitions for other species. In an effort to achieve habitat improvement agreements with state and private landowners prior to and possibly thereby precluding a listing decision, a voluntary pre-listing conservation program was launched in 2010, not by the U.S. Department of Interior, which includes the Fish and Wildlife Service, but by the U.S. Department of Agriculture. This government-led project was unusual for an at-risk species in that it was launched with the expressed intent to promote the long-term sustainability of ranching operations, while improving the population and occupied territory of the lesser prairie chicken. Conservation groups were keen on collaborative agreements, not only for the well-being of this grassland bird, but because of its ecological role as an umbrella species. Protecting the habitat needs of an umbrella species thereby also protects the habitat of dozens of other at-risk species, including plants. That project did not advance well enough to preclude a listing petition in 2012, which resulted in a formal listing as threatened in 2014. This action was overturned by the courts in 2015 when it was challenged by business interests associated with oil and gas extraction. Conservation groups resumed petitioning for listing of the species, with the executive branch repeatedly deferring a decision until 2022. So there you see right here, 2012 at the top, 2014, 2015, and now deferring a decision until 2022. It was then that a listing was finalized that classified the southern population as endangered and the northern population as threatened. However, in 2023, Congress passed a bill that negated the listing, which was promptly vetoed by President Biden. In 2025, a federal court in Texas ruled in favor of a case filed by the state of Texas and several petroleum companies that pointed to problems in the 2022 listing decision. The Trump administration did not defend against the lawsuit and even requested the court to overturn the listing rule. As summarized by the Sierra Club, quote, "The court denied intervention by environmental groups who sought to defend the rule or prevent its vacatur, which meant no party in the lawsuit objected to the Fish and Wildlife Service's about-face or acted to protect the species. February 2026, a regulatory posting delisted both the northern and southern populations." In sum, from 1998 to early 2026, 2 executive agencies of the federal government, 2 judicial actions, and 1 attempt by Congress to overturn a listing decision all played roles in how the Endangered Species Act would be applied to the conservation of the lesser prairie chicken. An even more complicated example is the gray wolf, as presented in a 2020 report by the Congressional Research Service subtitled "A Case Study in Listing and Delisting Challenges." Details of this report appear in a delisting section later on this page. So won't go farther into the wolf delisting challenge. That'll happen in another subhead. All right, moving down to disputes arising from science. The ESA, as amended, specifies the use of science in 2 distinct areas of decision-making. First, determinations whether to list and downlist or delist species must be made solely on the basis of science, without consideration of how a listing decision might adversely affect other national or regional priorities. Second, all agency decisions on managing species that are already listed must be made using, quote, "the best available science." Together, these 2 mandates have generated considerable discord and lawsuits on a variety of agency decisions. To begin, the statute requires that agency decisions on listings must not be influenced by political, corporate, or citizen concerns, that such listings could impinge on access to natural resources on public lands, or how private landowners choose to manage their own properties. Rather, listings are to be based solely on the science. But even peer-reviewed science publications can be at odds, thus offering grounds for opposing parties to each present rational arguments that their position is more in line with the science than that of their opponents. Additional points of contention arise when the best available science is clearly deficient. In these circumstances, even the Information Quality Act guidelines issued by the Federal Office of Management and Budget, along with the scientific integrity policies of the implementing agencies, may offer little support for resolving debates and thus preventing lawsuits. If staff time is already overwhelmed by existing legal requirements for decision-making, and if the budget lacks capacity for hiring research by contractors, decisions will have to be made, despite even large unknowns in the data and conclusions of science. Parties who strongly disagree with the agency decision may then utilize the Administrative Procedure Act to contest the outcome in court, if they can construct a good case that established agency norms for decision-making were violated. Overturn of the Chevron deference by the U.S. Supreme Court in 2024 may have amplified opportunities for judicial scrutiny of agency decisions to the point that even the best available science aspects can be argued in court. Next, we'll move to citizen rights to petition and sue. Among the most polarizing provisions in the Act are the rights awarded to citizens and their interest groups to compel the agency to make listing decisions, to specify critical habitat, and then to challenge in court such decisions. A 2016 report on the ESA by the Congressional Research Service wrote, "The citizen suit provisions of the ESA have been a driving force in the ESA's history and often have been used to force agencies to devote greater effort toward conserving the species in question. At least one study suggests that citizen groups drive listings of species that may be at greater risk than those proposed by the Fish and Wildlife Service itself." The same article presented data to support the thesis that citizen proposals for listings are more likely to concern species in conflict with development. ESA citizen suits seeking to list species or to challenge delays in listing decisions amount to a significant number of lawsuits against the Fish and Wildlife Service and the National Marine Fisheries Service. In practice, agency decisions are sometimes challenged by biodiversity proponents who assert that the best available science would compel stronger listing protections. The 2025 review also reports that the Act itself employs language that generates dispute among experts. Quote, "In addition, agencies spent valuable resources in courtrooms defending their definitions of subjective terms like significant portion of range, historic, critical habitat, foreseeable future, and even species, with many conservation scientists offering expert testimony. Overturn of the Chevron deference by the U.S. Supreme Court in 2024 may have amplified opportunities for citizens, pro and con, to obtain judicial scrutiny of agency decisions grounded in arguable, quote, best available science, and the unavoidably ambiguous standards written into the statute. Citizen suits are not unique to the Endangered Species Act. A 2004 paper reported that, quote, 16 of the nation's principal federal environmental laws invite citizens to sue, to force agencies to perform mandatory duties. With respect to the ESA, however, critics of citizen rights to petition for listing have charged that most citizen-initiated listings are driven primarily by political motives, particularly to Black development projects. Another argument is that, quote, citizens initiate listing of more subspecies and populations as opposed to full species, again, out of political convenience. Environmental interest groups are themselves sometimes divided on how the petitioning right should be used. Disagreement amplified when some environmental interest groups began submitting mega-petitions. A 2020 Law Review article stated that tensions were magnified in 2007 when the environmental group Wild Earth Guardians filed 2 mega-petitions that together proposed the listing of almost 700 species. The legal and political battles surrounding the mega-petitions hardened positions among stakeholders and politicians, including conflicting views within the environmental community. In 2011, a mega settlement was achieved by the agency, Wild Earth Guardians, and another biodiversity advocate group, Center for Biological Diversity. The settlement required the Fish and Wildlife Service to take action on pending petitions for 757 species over the next 7 years. In exchange, the 2 environmental groups agreed to limit lawsuits filed against the agency so that efforts could be focused on trying to accomplish the terms of the agreement. The following year, however, the Center for Biological Diversity submitted a single petition for listing a total of 53 amphibians and reptiles, spanning a range of 45 states. The petition entailed 454 pages. The list of citizen petitioners included 2 well-known ecological scientists, Edward O. Wilson and Thomas Lovejoy. This action provoked a written statement by the chair of the United States House Committee on Natural Resources. Quote, while the recent petition does not directly violate the terms of the settlement, it does divert money and resources away from species recovery and disregards the spirit of the settlement by adding to the agency's backlog of petitions. Time and again, the Center for Biological Diversity and other similar groups have undermined the goal of the Endangered Species Act by litigating, obstructing, and frustrating the Fish and Wildlife Service, while racking up hundreds of thousands of dollars in taxpayer-funded attorney fees that continue to feed their litigious strategies to the detriment of species and people. Arguments in favor of retaining citizen rights to petition for new listings include, quote, in many cases, outside groups could serve as the only impetus for protection of biologically threatened taxa that would otherwise be ignored because they conflict with development projects and related political pressures, or because they are low-profile subspecies. As well, thoroughly researched and data-rich petitions can actually assist agency staff in finding, evaluating, and including in the written decision, quote, the best available science. From a practical standpoint, citizen suits are unlikely to be launched frivolously because of the costs of attorney time, coupled with the need to obtain a win in order to benefit from court-ordered reimbursement of legal expenses. Finally, citizen suits provide important constraints on agency discretion when environmental statutory mandates and the ideological outlook of presidential administrations diverge. Now I'm going to skip this next section here, examples of judicial interventions, as this is the only subsection here in this entire challenges and controversies that I didn't write myself. I did some editing, but it was a lot more legalistic than I would normally put in. But nonetheless, as a Wikipedian, someone contributes something that has a good reference and is solid, you try to keep it in. So the only thing I show here are the critters that it's about. This one, dusky gopher frog. Down here, the delisting of the bald eagle in 2007. And this one here doesn't have a species associated with it. Now here is, as I recall, the most complex. I still can't really keep track of all the individual components to it, but the most complex of all the subsections that are included in this challenges and controversies section. So this one is rise in numbers and complexity of required documents. So the first subset here are decisions on petitions to list. Citizens, including non-governmental organizations, are empowered to petition a species or distinct population of a vertebrate species to be designated as threatened or endangered. Decision documents, first in draft, then in final, are posted in the Federal Register. Draft decisions are to be posted for comment within 2 years, but in practice, it often takes the agency much longer. A 2022 academic paper evaluated the wait times. And here's a quote from that paper. The period with the longest median wait time, 2000 to 2009, with a median wait time of 9.1 years, was also the period when the greatest number of petitions were received by the Fish and Wildlife Service, and that is 203 petitions. Because the statute directs the agency to use, quote, the best available science when evaluating a petition, no new scientific research needs to be conducted before issuing a response. Even so, staff time and resources may be substantial, partly to ensure that the resulting decision derives from a document that can allay disappointed stakeholders from going to court. Decisions on petitions have been most challenged when the Center for Biological Diversity, or Wild Earth Guardians, submit mega-petitions that request decisions on scores of species at the same time. Failure to meet the regulatory deadlines could subject the agency to judicial review. Only Congress can forestall those kinds of lawsuits. Thus, in 2011, the Fish and Wildlife Service itself requested Congress to impose a cap on the portion of the agency's total budget that could be spent responding to petitions. Recovery plans, critical habitat, and agency consultation. This is the one I have a very difficult time holding in memory. All right. A recovery plan, with or without critical habitat designations, is the major document prepared by the agency following a listing decision of threatened or endangered. Reviews of the plan, with updates if merited, are to be performed every 5 years. Below are the 2 stages of recovery plan documents with references that link to the ECOS online portal, where individual plans can be accessed. So you can find recovery plan in draft and the recovery plan after comments in final form. Critical habitat documents are accessible through ECOS portal by this title: U.S. Fish and Wildlife Service Threatened and Endangered Species Active Critical Habitat Report. As of February 2025, 964 designations have been published. Again, critical habitat documents. These are intended to assist the public in learning whether any particular acreage in the USA contains designated critical habitat where listed species and their essential habitat must not be harmed. And I have already pulled up the critical habitat document for one of the creatures that was mentioned in the previous episode, part 2, and that was the rusty-patched bumblebee. So let's go take a look. All right, this is posted in the Federal Register. Endangered and threatened wildlife and plants, designation of critical habitat for the rusty-patched bumblebee. And I just want to show here how detailed this is. We're going to see how many pages are involved. All right, we keep going through here. Keep going through. More. 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 Okay, I think we're getting close. Yeah, that's the end. So I just want you to see how much staff time is required for just fulfilling on the absolutely required legal documents. And this for a single bumblebee. And next, an overlay image of the map itself that shows in black the actual acreage and where it's located of the critical habitat designation within the very large range of this particular insect. Now back to the last subsection that we're going to be covering in this part 3 of the tutorial. And it's the very complicated one. It's called recovery plans. We've already done critical habitat. It's the end of this. And we're now going to go into agency consultation. The statutory requirement for other federal agencies to act in ways supportive of listed species is generally referred to as agency consultation. This is where the decision-making, documentation, and public participation becomes more complex. And so I'm just listing some of the actual titles of these documents. A Section 7 interagency consultation, Section 10 exceptions, incidental take statements, incidental take permits, habitat conservation plans. And then the ECOS portal, you can get these official documents: critical habitat report and consultation issued biological opinions. Distinctions between a biological assessment and a biological opinion, BIOP. And then incidental take statement, ITS. And finally, reasonable and prudent measures, RPMs. All right, continuing. Environmental impact statements, EIS, and subsequent permitting actions are administered by the Environmental Protection Agency, with requirements for consulting with the Fish and Wildlife Service within specified time parameters. The same holds for actions and permitting authorities of the Bureau of Land Management, Forest Service, and Army Corps of Engineers. Entities seeking development permits on federal lands may be required to develop habitat conservation plans, HCP, and that's at their own expense, not the government, that may include mitigation efforts, monitoring, and even supporting additional field science that the developer itself will be contracting for. HCP documents can be accessed individually by the development project title through the ECOS portal. For example, the Criterion Wind Power Project has an individual page. Its permit to proceed was issued in 2014 for a duration of 21 years. Subsidiary links include 2 versions of the HCP, that's Habitat Conservation Plan, 2 biological opinions, a NEPA EA, that would be environmental assessment, a NEPA FONSI, whatever that is, and a set of findings. And for that one, let's take a look at the Criterion Wind Habitat Conservation Plan. I've already found where that is, and I'll get to it right now. Okay, so this is what the Habitat Conservation Plan with the Criterion Wind Power Project. And so the applicant type, it's a corporation. The permit was issued in 2014, and it's going to last 21 years. And here's the Federal Register documents that talk about what it's about, environmental assessment. And here, this is what I wanted to show. These are all the plan agreement documents that have to be filed and approved before this can go ahead. And so here's what I really wanted to show, and that's that the endangered species that prompted all of this is the Indiana bat, Myotis sodalis. Wherever found, it's endangered. Okay, let's go back. Finally, although not subject to public comment requirements via draft publication in the Federal Register, the Fish and Wildlife Service has been making the recovery plan stage less complex by creating policy-free and science-rich species status assessments, SSA. These are posted on a dedicated ECOS portal with summary statements later embedded into the formal and policy-rich recovery plan documents. And so what makes this less complex is that the basic science can be put into a distinct document that is not subject to posting in the Federal Register, and it can be updated at any time new information comes in, and you don't have to go through a draft and a final, you just post an update. And so this tends to shorten the policy document itself that can be challenged in court, that is the recovery plan, because then only a summary of the science is put in, and it focuses on the policy and the recovery actions and other elements required in the law, such as population numbers and budget for being able to finally recover a species. Now, I do want to show you what the species status assessment documents look like. Okay, this is the ECOS page. Species with species status assessments, SSAs. And I specifically chose mammals in here. Here you see mammals. And so here's how this list starts. And what you should notice here is 2020, 2018. These all look pretty recent. And the reason for that, the reason it's recent, is that it wasn't until 2016 that the U.S. Fish and Wildlife Service instituted species status assessments. And often species status assessment it's not prepared by the staff. It could be state departments of natural resources, it could be scientists themselves with an interest, and then it needs to be looked through and approved by the science staff within the agency. So what's next is incentives for stopping development, and I'm going to hold off on that one until the next episode in this series. That'll be part 4. This is the end of part 3 of the multi-part series on the Endangered Species Act of 1973. The link to part 4 and later episodes can be found in the caption of this YouTube video. You'll also find a time-coded table of topics there, key to all of the subsection titles that have been covered thus far in the main section called Challenges and Controversies. I'm Connie Barlow.